Assalamualaikum warahmatullah. Good morning. Today we will look at the types of damage where the court is reluctant to impose duty of care. Okay, there are two. Number one is nervous shock or psychiatric illness, and number two is economic loss. For today, let us look at nervous shock or psychiatric illness. What is the meaning of nervous shock? Okay, first, definition. Nervous shock is a term to describe a medically recognized psychiatric illness. It includes all forms of mental illness that are medically recognized. For example, anxiety disorder or post-traumatic stress disorder, or known as PTSD. For this, you can refer to the case of Alcock. Now, why the courts are reluctant in awarding compensation? There are a few reasons. Number one, because it is difficult to assess injury or damage in monetary value, because most of the time the injury is unseen, because it involves psychiatric illness. Number two, because it is difficult to determine whether the plaintiff allegation is true or not. Sometimes a person might just fake his mental illness. Number three, because it is difficult to prove that it is indeed the defendant's act which caused the psychiatric illness suffered by the plaintiff. Meaning, it is difficult to prove causation as it is hard to determine the cause of the psychiatric illness. And lastly, the reasons why the courts are reluctant in awarding compensation because to avoid floodgates of cases in courts. So we know that litigation is a complex process that can be time-consuming and take years before it is finally resolved. Usually in court, there's always delay and backlog of tort cases in Malaysia. So we can see this problem where certain cases might take up to 20 years before it is finalized. For example, you can look at the case of Fu Fiona, which took almost 24 years, and also the case of Dr. Chin Yoon Hiap, which took 21 years to be settled by the court. So, if the court allows all nervous shock or psychiatric illness cases, there will be floodgates of cases in courts. Next, we will discuss the development of the law relating to nervous shock. Previously, you can see that the law only recognizes claims for physical harm as stated in the case of Victorian Railway Commissioners. The court at that time were cautious about admitting claims for non-physical harm like psychiatric illness because of the reasons that I've mentioned before. For example, because of risk of fraudulent claims and also difficulty of linking the harm suffered by the plaintiff to the defendant's negligent act. Then, because of the advancement in psychiatric knowledge, the position changed where the court allowed claims for nervous shock or psychiatric injury, even without physical injury. You can refer to the case of Dulio. In this case, the plaintiff suffered shock, which resulted in a miscarriage when the defendant's van crashed into a public bar where she was serving drinks. The court held the defendant liable for causing the plaintiff to be in fear of her own personal safety. So in this case, the English court allowed the plaintiff's claim for psychiatric injury when she was put in fear of immediate physical injury to herself. The defendant's negligence caused a van to break through a wall of her husband's house where she was standing behind the bar. Next, the scope of recovery was also expanded beyond the primary victim to include a secondary victim. We can look at the case of Hambrook. In this case, the court allowed the claim for damages. The mother, in this case, saw a lorry rolling down the steep street where her children had just passed by. The court held that it was unnecessary to prove that she was in fear of her own safety, meaning the court expanded the scope of recovery to include secondary victim, in this case, the mother. This means that the scope of recovery was also extended to include any person who sustained psychiatric illness due to fear of immediate physical injury to near relations. For example, you can look at the case of Hingun, which involve a wife, her husband, and children. You can also look at the case of Boatman, which involve a father and his son. In the case of Boatman, the plaintiff heard the cries of his 8-year-old son, whose foot was run over by a car. He rushed to help and later suffered from psychiatric injury. In this case, the Court of Appeal allowed the claim and held that the defendant owed a duty not only to the infant but also to the near relatives of the infant, i.e., the father. Lastly, the case of Zainab Ismail, which involved a mother and a daughter. In this case, a driver negligently drove his lorry and killed the plaintiff's daughter. The plaintiff saw the accident and suffered from shock. She was still sick after 2 years. So in this case, the court allowed the plaintiff's claim for nervous shock sustained as a result of seeing her daughter knocked down by the defendant's lorry. So we can conclude that previously, no claim of psychiatric illness without proof of actual injury. Later, we can claim even without proof of actual injury, and the scope of recovery was expanded beyond the primary victim to include a secondary victim. However, all these cases required that the secondary victim to be present at the scene of the accident or close to it so that the accident is perceived by his senses. Okay. Next, so what is the precursor of the current law? The requirement that the secondary victim must be at or close to the scene of the accident changed in the case of McLaughlin. In this case, the plaintiff was at home. She was at home when she received news from a neighbor that her husband and her 3 young children were involved in a serious accident an hour before that. She was taken to the hospital, and there she saw her family in extremely distressing condition, and she was told that her daughter had died. This caused her to suffer from psychiatric injury. In this case, the House of Lords allowed the claim, and the House of Lords held that although the plaintiff was not present at the accident, she had came to the hospital and saw everything very soon after the accident, i.e. 1 hour after the accident. The court stated that the shock must be from sight, i.e. seeing it or hearing it or its immediate aftermath. So this is what we call the aftermath test, which was introduced by Lord Wilberforce. The test listed down these 4 factors that must be considered. Okay. So the current law is based on the case of Alcock. In this case, it involved a disaster at a football stadium, and that disaster caused psychiatric injury to a number of persons who saw part of the event on television. Okay, so the House of Lords in this case refused to allow recovery because in this case, the pictures that were shown on the TV of the chaos did not show the suffering of identifiable victims. However, in this case, the court did not rule out the possibility of such claims. Based on the case of Alcock, the requirements for the recovery of damages in cases of psychiatric illness can be summarized as follows. Number 1, it must be reasonably foreseeable that damage in the form of psychiatric illness will occur. So it must be foreseeable that the plaintiff will suffer nervous shock as a result of the defendant's conduct. And the court will consider several factors, including relationship between the plaintiff and the victim. And the relationship should be based on love and affection, such as those involving, for example, spouses and between parent and child. However, the court also recognized certain exceptions where persons who do not have any kind of relationship with the victim may claim for psychiatric injury. For example, cases involving a rescuer or bystander. Number 2, psychiatric illness must be as a result of what the plaintiff himself perceived with his senses. Meaning, the plaintiff must see the event or its immediate aftermath with his own senses. Okay, that's clear. Number 4, the means by which the plaintiff comes to know about the accident is relevant. And lastly, the plaintiff must suffer a medically recognized psychiatric illness. So it must be a medically recognized psychiatric illness, an anxiety disorder or post-traumatic stress disorder caused by an assault upon the nervous system. Okay, you can refer to the case of Bryce and also the case of McFarlane. Next, primary and secondary victims. I've already mentioned primary and secondary victims before, but who are they? Number 1, primary victims. Primary victims are victims that directly involve in the accident. Please, you can read the case of Page and Smith. Okay. Next one is secondary victims. A secondary victim is someone who is not directly involved in an accident, but merely witnessed it or arrived after the accident. You can read the case of White and others, where in this case, establish that sufferers of psychiatric injury who are not either physically injured or in danger of being physically injured are to be considered secondary victims. So, that's all on nervous shock or psychiatric illness. I want all of you to answer the questions that I've posted online for your attendance. Next class will be on, I believe, on 6 May, and we will discuss on economic loss. Okay? Thank you so much. Assalamualaikum warahmatullahi.